Going on the record, State of Wisconsin versus Daquela Collins, case 25 CF 1634, appearances.
Matthew Tarbinson appears for the state. Good afternoon, Your Honor.
Attorney Abigail Ruckdashel on behalf of Ms. Daquela Collins. She appears in person. Good afternoon.
Cell phones, please.
All right, she's in person. Good afternoon, Ms. Collins. We are here for a sentencing following guilty pleas to 2 counts. 1, neglecting a child where the consequence is bodily harm as a party to a crime. That's a Class H felony. And count 2, straw purchase of a firearm, a Class G felony. I believe we're ready to go. Don't believe. I don't have any pretrial filings that speaks to anything, character letters or victim impact statements or anything like that. Is there anything I should have from the state's perspective?
No.
From the defense?
No.
All right, then I'll hear from the state first.
Your Honor, the state's recommending that the court sentence Ms. Collins to a term in the Wisconsin State Prison System of 3 years initial confinement, 4 years of extended supervision. On April 1st of 2025, Ms. Collins' 6-year-old son, Daquell, accessed a firearm. He possessed that firearm and used that firearm, ultimately resulting in a gunshot wound to his head. Just after 9:30 in the evening, Ms. Collins' mother, Alicia Collins, discovered Daquell with a gunshot wound to the head. She immediately phoned 911. Emergency responders arrived on scene within minutes and attempted life-saving measures on Daquell's body. Those life-saving measures proved unsuccessful, and Daquell was pronounced deceased on scene. Daquell was just 3 days shy of his 7th birthday when he died. The death of Daquell was completely and wholly preventable. We have a problem in Milwaukee County with firearms. We have a problem in Milwaukee County with felons possessing firearms. We have a problem in Milwaukee County with individuals like Ms. Collins purchasing firearms and giving those firearms or allowing felons to use those firearms. An argument can be made that Ms. Collins suffered the greatest penalty one possibly could for her actions already, because by providing her brother a firearm, by allowing her brother to access her own firearm, she has lost the life of her son. And there probably is no greater penalty for Ms. Collins for that. But when one examines Ms. Collins' text messages in her phone in the month leading up to what happened, it demonstrates that Ms. Collins, with her brother, was acting in concert to get him a gun, to allow him to possess a gun, to allow him to make arrangements to sell her firearm to others in the community. All in an attempt to avoid the consequences. Quintell Collins was a convicted felon. He had just been released on extended supervision for his felony fleeing offense approximately a month or so before this took place. Ms. Collins knew her brother was a convicted felon. She knew he was not to possess a firearm, and she facilitated him getting a gun. She actually asked him to assist her in purchasing ammunition for her own firearm. The two would communicate fairly regularly about firearms through text messages, and it was during the late morning hours, just after 11 o'clock in the morning on April 1st of 2025, when Quintell sent a video on Instagram where he was rapping, holding Ms. Collins' firearm and his firearm. Haunting in that video are the feet and the legs of Daquell that can be seen laying on the back of the couch. Also haunting in this case are the text messages that Ms. Collins sends to her brother in the weeks before, because she talks about how her son looks up to Quintell, how her son sees Quintell with this firearm that is, according to Ms. Collins, something that Quintell carried every single day with an extended magazine, a convicted felon, in her home, in front of her own child. And here we have a 6-year-old child doing what children do. Children are fantastic mimickers. They watch adults and they want to be like adults. Daquell saw Quintell with a firearm. He wanted to be Quintell because this was glorified. This was cool. And it cost him his life. So in some respects, I understand that Ms. Collins has suffered a great penalty already through her own conduct. When she received that video on April 1st of 2025, she sent a text message back to Quintell telling him to put her gun up. Ms. Collins also, according to what she told law enforcement, called her mother and asked her mother to address the situation. She had a video demonstrating the danger right before her. She sent a text message to someone who's completely unreliable and sent a laughing emoji back to her, and then sends a message to her mother saying, "Can you also take care of this situation?" And then went about life as if it were normal. She didn't take any additional steps to protect her child, to get those guns away. Again, it seems to be just routine and acceptable conduct. I would think a parent who got a video of this with their child in the room would find it extraordinary, would find it alarming, would find it concerning, and will want to take actions to protect their child. To Ms. Collins' credit, after the death of her child, she's the one that provided the video of Quintell. She gave a full statement to law enforcement regarding what was taking place, at least with regards to Quintell possessing the firearm. Ms. Collins said that she purchased the firearm because she knew her brother was a convicted felon and knew that he brought a firearm into the house and that he brought drama. And therefore, she felt that she needed to possess this gun for protection. Those statements to law enforcement stand in contrast to the text messages that she exchanges with Quintell. It does not appear in her text messages that she's afraid of the people that are coming around as a result of her brother being released, having a gun, and engaging in the conduct that he did. It seems like she is embracing that conduct and wanting to be a part of that conduct. But Ms. Collins does deserve credit for, at least in some aspects, being cooperative with law enforcement, providing the video to law enforcement. With regards to Ms. Collins' character, she has one prior criminal conviction. It's a misdemeanor conviction. It's a retail theft from another county. It's from 2021. Beyond that, I see no other criminal conduct on the part of Ms. Collins. So before this, she had one conviction and for a relatively minor offense. Ms. Collins also deserves taking credit and accepting responsibility in this case by entering a plea, not taking the matter to trial. Certainly, she could have tried to take this case to trial and point the finger at her brother as the main person that was involved, though the text messages would have proved that to, from the state's estimation, be a futile attempt. With regards to protection of the public, there is a need for both specific deterrence and general deterrence in this case. The need for general deterrence in Milwaukee County is huge. should be consequences for individuals who provide firearms to convicted felons. And that's what Ms. Collins did. Our community at large needs to understand that there's going to be consequences, that there's going to be punishment if you try and avoid the laws by facilitating convicted felons getting guns. The state believes that there's also a need for specific deterrence with regards to Ms. Collins' punishment for her own actions in this particular case. Again, I understand that she has suffered a great loss as a result of her actions. I've taken that into account in two ways. First, in the reduction on the child neglect charge that she entered a plea to. She is not facing a homicide charge for which she was originally charged. And secondarily, I've taken it into account in the recommendation I've made before Your Honor with regards to the amount of time I'm recommending in prison. For all those reasons, the state is respectfully requesting that the court follow the state's recommendation of 7 years in the Wisconsin State Prison System, 3 years of initial confinement, followed by 4 years of extended supervision. I would leave the conditions of extended supervision up to the sound discretion of Your Honor. Thank you.
Thank you. Ms. Ruckdaschel?
Thank you, Your Honor. Every single person that's in your gallery right now is here to support Ms. Collins. I think that we're getting close to 24 people here. I think you can see that there's a lot of friends and family members that are here to support Ms. Collins, not only as she navigates this criminal case, but as she navigates the loss of her own son. The main person that's here that I know Ms. Collins relies on is her mother, Miss Alicia Collins. She's in the front row in the pink. I know Miss Alicia Collins wanted to address the court at one point, but is feeling a little bit too emotional to do so today, and I think the court can understand that.
Sure.
I know this court knows the galleon factors it must take into consideration here. Obviously, protection of the public. It's clear Ms. Collins is not a threat to the public. This isn't a shooting that happened and her son was caught in the crossfire or something like that. She wasn't shooting at anyone or being any type of reckless or doing any type of violent crime. She has been out on Justice Point since April of last year. As far as I can tell, there's been no issues with Ms. Collins being out on bond. She reports to Justice Point. She follows this court's order, this court's orders. As far as character of the defendant, Ms. Collins, at the time that this happened, was working a job. She was working at a group home. When she received that message from Mr. Quintell Collins, she was at that job. She did respond to Mr. Quintell Collins when she saw the video and said, you know, something along the lines of, like, don't do that in front of my son. And then he, in his immature ways, sends back a laughing face. Now, should Ms. Collins have followed up? Of course. Now, Ms. Collins did talk to her mother, Miss Alicia Collins, who is the owner of the house where Ms. Collins, her kids, and Quintell Collins were living. I don't know if that message ever made it to Quintell Collins or if it was too late or what happened with that. The issue that I have here, Your Honor, is sometimes we get caught in our own world here where we think people can leave their jobs whenever they want, run home, do that. Ms. Collins wasn't working a job where she could just leave whenever she wanted. She was working at a group home with elderly people, and if she would have just left, those elderly people would have been left alone. That's not something that her job allowed her to do. It's not like she was out in the club. It's not like she was out at a bar and just decided not to come home. She was working a job to provide for her kids. Ms. Collins was arrested. I believe that she has 16 or 17 days of credit from this incident. She did post bond, which was set at $10,000 and has been out on bond that entire time. When she originally was released from custody, she went back to that group home job, but was ultimately asked to leave that job given that the state licensing requirements for that group home. They told that group home they can't have someone who's charged with a felony working at that group home. I think that makes sense whether or not we agree with it. Ms. Collins then took it upon herself and has been working at Amazon since then. She works 4/12s, So she has works 4 on, 3 off. And on her off days is when she schedules and takes her children, her 2 remaining children, to therapy. One is 4, one is 2. Obviously, it's a little bit hard for children that little to sort of process what they've gone through and things of that nature. So I am really proud of Ms. Collins for taking her kids to therapy, no matter how little they are. I believe they go to what's called shoreline therapy. They have offices in Wisconsin, Illinois, and Colorado. The 2 kids do their therapy together because I'm told, I don't know if it stems from this incident or what, or if it's a trauma response, but the 2 children cannot be separated from each other. The 4-year-old and the 2-year-old have to be together all the time. They only have 2 people that they feel safe with, Miss Daquela Collins and Miss Alicia Collins. If they try to go with other friends and family members, they cry, they will not do it. I think that's understandable given the traumatic loss of their brother. Miss Collins also receives therapy, and she was quite candid with me when she said, it's really hard for me to process what happened with my brother. She still wants to love her brother and forgive her brother, but I think rightfully that's hard to do when he is responsible for the death of your child. And I think she's wrestling with those emotions, and I'm glad that she is seeking professional help to work through those emotions, because I'm sure they're not easy. That's not easy to do. The family also receives family therapy, again, from Shoreline Therapy, and I am hopeful that there'll be positive outcomes for her 2 remaining children, and for Ms. Collins, but specifically for her children here. As the state said, Ms. Collins cooperated with police. She showed them the video. She even identified her brother on a surveillance footage for the officers, as well as Quintell Collins is running away in the alley. I think that leaves, Your Honor, the severity of this offense. And anytime a child, specifically a small child, leaves this world, it's a horrible and terrible offense. And I'm not trying to minimize that loss to this family and to this community, but Ms. Collins' part in that is small. I think that this case is different, even if Ms. Collins does nothing when she receives that video. The fact that she even responded to her brother and told her brother what to put that gun away shows that she was trying the best that she could under the circumstances as being a working mother. Now, we can all have different opinions as to what Ms. Collins should have done, but I think it boils down to this. You should be able to trust your own brother. Even if your brother is a felon, even if your brother is being, for lack of a better word, a dumbass and rapping with firearms, you should be able to trust your brother around his nephew. And I know that Ms. Collins feels betrayed by the fact that she wasn't. I also would like to note that in this situation, there were 2 firearms, the one that Ms. Collins purchased and the one that Quintell Collins apparently had, the one that Quintell hid under the garbage can and then came back, but police had already found it. So it happened to be Ms. Collins' gun that, unfortunately, Daquarius/King was able to get a hold of. But there was also another gun, and I actually think that cuts both ways here. But I think it's worth mentioning that the fact that Quintell Collins was in this house at all, I think, was a danger to King. And that isn't Ms. Collins' choice or fault. Some people don't have anywhere else to go. But again, I still think you should be able to trust your own family. I have another case where with a client left her child with her boyfriend who was clearly not responsible. I think that's different here because this is blood family. And I think you should be able to trust your blood family when your children are part of them too. So I think it comes down to this: how much do we punish Ms. Collins? That's the only thing that's left. The Gallian factors point towards her being of good character, not a danger to the community. And I think her part in this offense that overall is severe is quite small. The state said it, and I'm going to say it again. I think losing her son is punishment enough. I really do. I think a prison or a jail sentence is going to shake up this remaining family even more than it already has. Miss Collins is doing what we would ask anyone in this situation to do. Get therapy for yourself, get therapy for your kids, be a contributing member of society. That's what she's doing. I looked up some information from the National Institute of Justice about general deterrence. They say that evidence suggests that general deterrence has a limited effect. It's usually the threat of legal consequences that prevents crimes, but research shows that certainty of being caught is vastly more effective than any sort of severity of punishment. I understand, I live in this community, I know that guns affect this community. I know people helping people who aren't supposed to have guns is a huge problem in this community. Everyone in this courtroom lives here and knows that. There is too much of these type of cases where someone who's innocent ends up dead. There's too much. But this court doesn't see probationary sentences that often. That is what I'm asking this court to impose. I believe that all of the galleon factors that this court must consider points to that. And I don't believe a prison sentence does anything here for general deterrence or specific deterrence. I think that Ms. Collins would be the first one to tell you she doesn't need to be deterred from any type of this or any type of criminal conduct ever again. And I don't think general deterrence is something that is going to work in this situation. I wish that I had a magic wand to figure out a way to stop gun violence in our communities, but sending Ms. Collins to prison isn't it. I worry about her two remaining children and how they would be without their mother, one of the two people in this entire huge family that's in the gallery that they feel safe with. She is doing what she can do to hold her family together during this extraordinary loss. I'm asking the court to consider staying 3 years of prison and putting Ms. Collins on probation. Quite frankly, I think her only probationary needs are to make sure that she stays out of trouble and make sure that she continues to not contact her brother and to make sure she continues to do the type of therapy and rehabilitation she needs to do for her and her children. There's no AODA needs. I don't think there's any mental health needs. If there is, they're being addressed by the therapy she's already enrolled in. And quite frankly, I think prison would exacerbate some of the issues this family is facing. That's all I have, Your Honor.
Thank you.
Want to say anything?
Ms. Collins, what did you want to tell me?
No. Judge, Ms. Collins had something written that she wanted to read, but she's feeling a little bit too emotional. So I think we'll call it
Like
good.
to read it for her?
That's okay.
Okay. All right. Give me a minute. So she was at work at 9:30 that night. What time did she start work?
What time did you start work that day?
I got there at 7.
7 p.m.?
Yeah, I did first and second shift.
She got there at 7 p.m. that day, Judge.
7 a.m.
Oh, 7 a.m. So were you working?
I did
You're
first
14
and
and a half
second
hours?
shift.
Oh, she worked a double that
I
day.
worked first and second shift.
That's what you were saying. I
The
misunderstood.
criminal complaint speaks of you being at your boyfriend's house when you got the email, or
That was the day
got the video.
before. That was the day before on the 31st. She was at her boyfriend's house. She was at work on the 1st.
Okay. The video was sent the day before?
No, the video, I believe, is sent that day.
She saw it when she was on break from work. She went to her boyfriend's house on the 31st and went to work that morning of the 1st.
I'll pull up her statement, Your Honor.
Please do.
Yeah, Judge, the message was sent at 11:28 a.m. on April 1st, 2025. She left her residence at 1:30 p.m. on March 31st and spent that day with her boyfriend, and that night, she left for work the morning of April 1st from her boyfriend's house. And she received the message at 11:28 a.m. in the morning when she worked first and second shift at the group home.
All right. So whenever I sentence anyone, I need to consider three separate things: the gravity of the offense, the protection of the community, and the character of the defendant. I acknowledge Ms. Collins's loss of her son. And I acknowledge that that must be an unbearable loss. I also acknowledge that you're right, not everybody can get up and walk out from work and say, I can't do this. I have to go home. There is an emergency. However, I also acknowledge that we live in a society where there are rules. And there are rules whether someone's your blood family or not. And while it's true that as far as we can tell, Ms. Collins has complied with this court's orders, she acted remarkably recklessly with regard to her brother and the absolutely and positively cavalier way that she dealt with these guns. This story, these facts, I shouldn't put it as it's a story, would be taken in a different light if we didn't have the benefit of the text messages. Because if this were really someone who said, you know, I have my own gun for my own safety. It is locked in a safe. No one has the key. No one has the combination. It's me, it's me, it's me. Oh, he took a hammer to the safe and broke in and got that lock open, and he got it, and there was nothing I could do about it. That would be a very, very different conversation. I think this is one of these things that everybody thinks that could never happen. That would never happen. My 6-year-old would never pick up a gun. He knows better. Except when you're 6, almost 7. You don't always make the best decisions. That's why we don't let kids enter into contracts. We don't let kids drive. We don't let kids get credit cards. We don't let them make grown-up decisions because they're kids. I remember once I was in 7th grade. My sister had just gotten married, and her sister-in-law, so my brother-in-law's sister, decided to take me to a festival. And she smoked, and I thought that was so cool. And she said, "Did you want a cigarette?" And I said, "Sure," as if I smoked all the time. I was so sick because I didn't smoke, but I was certainly trying to be cool. Because we do things that people we think are cool. We're like, "Oh yeah, I'm grown, I can do that." I don't even know that he had the capacity to think I'm a grown-up, I can do this. All he knows is he thought his uncle was the shit. He probably thought his uncle was the coolest thing he'd ever seen. And you knew that because all he was doing was talking about it. And the two of you were talking about this. Is there any word on the heat? Nope, just said shipped. As if it's the toaster you're ordering from Amazon. Is it here yet? Nope, just said shipped. Okay? You tell him to stop popping pills. And which is good sisterly advice. But you know he's apparently doing drugs. He says he doesn't want to go to jail. I don't know what it means when you say someone's coming with a gun and a broom. Maybe that's literal, I don't know. And then he says to you, March 20th, "You can hold this gun until I pay you all your money if you want to after." Then you say, the next day, "Don't be leaving that gun anywhere in here because my son is steady talking about it." You knew he wanted to get his hands on it. You say, "My gun came," and he says, "I'll call you in a minute." Then you tell him, "Bring me my gun now." He's not supposed to have a gun. You know that. "Did you ever get me some bullets?" And he says, "No, not yet." So you're using him to get you what you need for this in your mind. And he's apparently going to sell it for you. Somebody got $600 for your gun right now. Then he asks you if you want to make a quick sale, and you discuss reporting the gun stolen and then selling the gun. And he asks you for his clip back, and you give it to him. You say you'll give it to him. And when he sends you a video that shows him playing with the guns, your reaction is not to say, "Oh my God, my son is there. Mom, go make sure my son is safe." You tattle on him. Tell him to put my stuff up. In retrospect, I think your concern was for your son. And I acknowledge the pain you must be going through must be unfathomable. But you're tattling like a sister does. He keeps touching my stuff.
Judge, I apologize for interrupting, but just to provide some further context, on page 33 of the police reports in the defendant's interview, she admits that she was at her boyfriend's house when she received the Instagram message at 11:28 in the morning, not at work. She also doesn't send or call her mother until 3 o'clock in the afternoon because her mother worked a double that day. It was her mother that worked a double, and her mother didn't get off of work until 3 p.m. So the first contact she had with anyone else in that residence, other than sending the single text message back to her brother, was her mother at 3 p.m.
The criminal complaint was murky. I appreciate your clarification. Do you agree with it, that that's what that police report says?
Ms. Collins
in her
tells me
own
that's not
statement?
true, so,
But that's what she said. Do you agree that that's what she said in her statement?
yes,
And now she says it's not true?
correct.
Okay.
They have proof of me being at work.
Regardless, you didn't take steps to protect him. You wanted to protect your stuff. He didn't pay you for it yet. You wanted to stop touching my stuff, whether he was going to pay you for whatever. The fact is, this baby was there. And Ms. Ruckdaschel is absolutely right. You should be able to trust your family to protect your children. But when they send you absolute billboards full of information that says, I'm not protecting your child, you have to act. And this is what those text messages are. These text messages tell you over and over and over, I'm concerned about myself, that he wants to have guns. You think he's always bringing drama. There's always stuff going on there. And you get the video. Now, I understand you say in your statement, I was at my boyfriend's and I knew I couldn't call my mom until she got home. You say now you were at work, regardless. Regardless. Your baby is there, and someone you don't trust is messing around with guns. And the next thing you know, he's dead. The first thing I have to consider is probation. I simply do not believe, in light of what was just such a blatant disregard of the law. I understand you weren't the one that couldn't have guns, he was, but you were absolutely all in on this and you knew he couldn't have them. And the law does not carve out something that says, well, you can live in a house with a gun if you're a felon because it's your blood, because you didn't have anywhere else to go. I understand it can make things certainly very uncomfortable for people. He'd just gotten out, he didn't have a plan, whatever. The fact is, though, that's not the law. The law is felons can't have guns, and you were working with him in this gun, and you're convicted of straw purchase of a firearm. So I don't believe probation is appropriate. I don't know what needs would be met other than the specific and the general deterrence. Because the message does need to be sent to the world that this isn't just a suggestion. It's not just a, yeah, if you feel like it, probably don't have a gun if you're a felon. No, you can't. Disagree with that all you want, but the fact is you cannot. He could not, and you knew that. And you entrusted your most precious resource to his care. Probably because you had to work, your mom had to work. It sounds like you both worked really, really hard. And you needed someone to care for your child. But you can't have this horrible combination of guns and caregiving and just hope nothing's going to happen. Because nothing happened in the past. We've lost all of the wonderfulness that could have been him. He could have grown up to be anything. He could have grown up to be a really hard worker like you and his grandma. He could have grown up to realize that breaking the law is not the way to go. And he was denied that opportunity. I don't think probation is appropriate here. This is just simply too serious. And I do recognize that the state has reduced the charge and they are making this recommendation, which is nowhere near the maximum that you're facing for these two charges. So it'll be prison, and I will get to that at the end. And I understand your argument, Ms. Ruckdaschel, as to the damage it's going to do to this family. And I'm so sorry for Grandma, who's now got two of her children, who lost her grandson, who has those two babies, who have suffered this trauma. I don't believe they're damaged beyond belief. I know that she's going to be able to care for them until you can come home to continue. Because I don't dispute that you have been caring for them. I appreciate that you're taking them to therapy, that you're recognizing this and not just ignoring it or saying, we'll deal with that after my stuff is done. You're recognizing their trauma. And I think that bodes well for them and for you. Conditions of time that you are serving. Oftentimes I'm asked not to order that there be no contact with the victim's family. You are the victim's family. So I'm not going to issue anything. I will continue the no contact order with the person who has their case open. I'm not going to order a no contact order with your brother because you're going to work this through at some point. I don't know how. I don't know how you come back from this. But I'm not going to order a no contact order. I don't remember if you told me, did you graduate from high school?
Yeah.
Okay. I mean, that's my bar. That's my kind of my low level. Everybody, I think, needs that. I encourage you to take any educational or vocational programming that you can to put yourself in the strongest position to be there, be productive, to be there for your kids, and to use this time in the best way that you can. Is it 16 or 17 days?
I think 17, Judge.
All right, 17 days sentence credit will be ordered. You'll have to pay the DNA surcharge as well as any mandatory cost, fees, and assessments. I can't do anything about that. The non-mandatory, or the mandatory ones. I'll waive the non-mandatory, but you will have to pay DNA and mandatory. That'll be due and payable from your prison funds at a rate to be determined by the Department of Corrections, then will be payable as part of your extended supervision, and then it will convert to a civil judgment. Is there any request for restitution?
No.
Restitution will be set at 0. Due to the nature of this, I am going to find that you are not eligible for the challenge incarceration program or the substance abuse program. I don't believe those are issues that need to be addressed with you. I am going to order that you have a full mental health assessment, and that is not because I believe you have a mental health problem, like a diagnosis before this. I think you're going to have to learn to deal with all of this. And I want you to have that evaluation and continue on with your own therapy, so when you get out, you are as healthy as possible, to assist your kids as you all work through this. They're going to not only have suffered the loss of their brother, but they will have suffered that you will be gone for a while as well. You may not have any firearms as you are now a convicted felon. Mr. Torbenson spoke of a problem we have in Milwaukee. There are thousands upon thousands upon thousands of people who don't have firearms. Because I sit in this court, I hear from people day after day after day, "Well, it's dangerous out there, I need a firearm." You know what? That's not working for anybody. You are now among those who can never have a firearm. And I hope you respect that. You never have one again. Never be around them. Nobody is winning. No one in Milwaukee is winning by just getting more and more firearms. You're saying, oh, well, you have a regular firearm, so I'm going to get an extended magazine. Oh, you have an extended magazine? I'm going to get a switch. Like, it's just escalating beyond everything. Nobody's winning. Be the person that says, I want to be there for my 2-year-old and my 4-year-old, so I'm never going to do this. Because if they find it in my purse, I'm going to prison. Respect that. You cannot vote until your civil rights are reinstated. You may never possess body armor. If you violate, well, I didn't order that. So you do have the right to appeal my sentence. Your attorney will go through those rights with you. On this, I'm going to run these counts concurrent to one another. There were decisions made at different points that led up to this, but I believe it was all part of twisted sense of whatever you were doing with your brother. I will sentence you to 6 years on count 1 in the Wisconsin State Prison, 3 years initial confinement, 3 years extended supervision. That will be concurrent to count 2. On count 2, I will sentence you to 6 years in the Wisconsin State Prison, 3 years initial confinement, 3 years extended supervision. I know I just said a bunch of numbers. That means 3 years in. That's the bottom line number for you right now. And that's 17 days credit will apply to both because of the way I've structured the sentence. I wish you well, Ms. Collins.
No.
Knock it off and put your phone away. Knock it off and put your phones away, or they're going to be taken and the deputies are going to take action.
I love y'all.
No.